Judgment in the appeal, Gohil and Gohil.
Lord Wilson will explain the decision of the court.
The court has heard Mrs Gohil's appeal together with that of Mrs Sharland. For, like Mrs Sharland, Mrs Gohil has applied for the financial settlement which she agreed with her former husband to be reopened on the basis that at that time he deliberately failed to make full disclosure of his resources. Mrs Gohil's financial settlement was reached in 2004. The marriage had lasted 12 years, and Mr Gohil was a solicitor. By some modern standards, the terms of the consent order were modest. Mr Gohil was to make to her a lump sum payment of £270,000 and periodical payments of £6,000 a year. She had alleged that his lifestyle was lavish and that he had substantial resources, particularly abroad. But his case was that assets which appeared to be his were instead owned by his clients, that in truth his liabilities exceeded his assets, and that he was able to offer the modest lump sum only with the help of his parents. A recital to the consent order, to which I will return, said that Mrs Gohil did not accept that Mr Gohil had made full disclosure of his resources, but that she agreed the terms in order to achieve finality. It was in 2007 that Mrs Gohil applied to set aside the 2004 order. In 2012, Mr Justice Moylan granted her application and made directions for her financial claims to be heard afresh. The delay was largely attributable to the fact that in 2008, Mr Gohil was charged with laundering about £25 million, which one of his clients, Mr Ibori, had corruptly obtained in Africa. In 2010, Mr Gohil was convicted, and in 2011, he pleaded guilty to further similar offences. He was sentenced to a total of 10 years in prison, where he remains. In 2014, the Court of Appeal allowed Mr Gohil's appeal against the judge's order that the 2004 order be set aside. It is against that decision that Mrs Gohil appeals. This court unanimously allows her appeal and restores the order of Mr Justice Moylan. The result is that her claims may now proceed to be determined afresh. In order to reach his decision to reopen Mrs Gohil's claims, the judge had applied two alternative tests, each of which he held to have been satisfied. One was the correct test, namely that Mrs Gohil had to prove non-disclosure in 2004, and, if I may oversimplify it, that had Mr Gohil made full disclosure, the settlement would probably have been different. But the judge's application of the alternative test was incorrect. It was based on Ladd against Marshall, the decision in 1954 in which Lord Denning famously identified the three criteria by which the Court of Appeal will decide whether to allow a litigant to put forward fresh evidence in the course of an appeal. Mr Justice Moylan decided that the evidence which Mrs Gohil presented to him satisfied Lord Denning's criteria, and that on the alternative test it followed that her application should again be granted. The Court of Appeal correctly held that this did not follow at all. Then, however, the Court of Appeal held that Lord Denning's criteria had a different relevance, namely that in her necessary attempt to prove material non-disclosure under the correct test, Mrs Gohil could rely only on evidence which satisfied Lord Denning's criteria, and that, since her evidence didn't satisfy them, it hadn't been open to the judge to find it proved. We're driven to the conclusion that in this respect, the Court of Appeal's analysis was wrong. Lord Denning's criteria apply only when a litigant, unlike Mrs Gohil, has already had a full opportunity to put forward evidence. Indeed, in saying that she could have proceeded to court in 2004 and could then have called evidence about Mr. Gohil's resources, the Court of Appeal forgot that the duty to set out his resources would have lain upon him rather than upon her. We conclude that Lord Denning's criteria are irrelevant to this situation. Mr. Gohil also argues that by that recital to the 2004 order, Mrs. Gohil accepted any risk that he hadn't made full disclosure. But his duty to make full disclosure was primarily to the court, and nothing said by Mrs. Gohil could absolve him from that. The recital has no legal effect. That is why we allow Mrs. Gohil's appeal, but we have had to think hard about whether to restore the judge's order or to direct that he should take a fresh decision whether to reopen the settlement. The complication is that in finding non-disclosure proved, the judge, through no fault of his own, relied heavily on evidence lifted from Mr. Gohil's criminal proceedings, which, in a separate appeal presented by the Crown Prosecution Service within weeks of his decision, the Court of Appeal held to have been inadmissible. We conclude, however, for reasons given in my judgment, but in particular in the concurring judgment of Lord Newburger, that in the light of the judge's findings upon the admissible evidence adduced by Mrs. Gohil, he would, by reference only to that evidence, again have found Mr. Gohil guilty of material non-disclosure, with the result that his order can properly be restored.
Thank you. The court is now adjourned.